Imagine your employment requires you to drive a motor vehicle as part of your employment. You unfortunately become involved in a motor vehicle collision due to no fault of your own. You sustain injuries and are transported to an urgent care facility where you undergo a series of diagnostic studies. The studies find you have a serious health condition that requires immediate medical attention and surgery. You remain hospitalized for several days, and following your discharge, you are informed by your employer's insurance company they are not going to pay for your hospital surgical expenses. This happened to one of my clients who I will call Lightning McQueen. Lightning was returning to his shop in a company truck with several co-workers when they were struck by a semi-tractor trailer. My client sustained numerous injuries, including head trauma. The emergency room physicians ordered a CT scan to determine whether he had sustained a concussion. The CT scan revealed he had a rather large brain tumor. He was immediately admitted to the hospital. A surgeon was called in and he underwent brain surgery for removal of the tumor. Following Lightning's release from the hospital, he was billed by the hospital for the hospital expenses after his employer refused to pay. Injuries sustained in a motor vehicle collision while performing work activities will be found compensable. Mr. McQueen was returning to his shop in a company vehicle. There is no question the injuries he sustained from the collision are compensable. If the accident had happened while making a personal side trip, returning to his shop, his claim would have been denied. So who's responsible for the hospital medical expenses? The motor vehicle collision occurred in the course and scope of Lightning's employment. He was performing a job-related task. He was returning his company vehicle to his employer's place of business after completing a day of service calls. The answer is the employer is responsible for the hospital emergency room care and the diagnostic studies performed to rule out a closed head injury. The CT scan was a necessary diagnostic tool to evaluate the severity of Lightning's head injury and determine whether there was evidence of a concussion. My client, however, is responsible for the hospitalization and surgical expenses for the tumor removal. The medical evidence reflected the tumor predated this incident. My client had no symptoms reflecting evidence of a brain tumor prior or after the work injury. Removal of the tumor was an elective procedure and not required as part of the treatment of his work injury. Now, the outcome of this claim could have gone differently if the head trauma from the collision caused movement of the brain tumor and onset of symptoms. The employer can be held responsible for treatment of pre-existing conditions if there is an identifiable and significant aggravation of a pre-existing condition. My client's tumor was a pre-existing condition. There was no evidence of movement of the tumor or that it became symptomatic following the head trauma. My client was responsible for the medical expense for the tumor removal. I'm Craig Armstrong, and since 1983, I've been helping Oklahoma residents who are injured at work get the proper compensation they are entitled to receive. If you've been injured at work and have an insurance claim or Social Security claim and are being pushed around, visit my website and set a time to meet with our firm. Also, if you need more information about workers' compensation, check out the rest of my videos on my site and channel. Imagine, while at work, you become lightheaded and you pass out. You fall and end up sustaining serious injuries requiring hospitalization. You start to receive medical bills from the hospital, and your employer tells you they are denying your injury and will not pay the medical bills or offer any medical treatment. Should the employer be responsible for the injury since it took place at work? This happened to a client I will call I Am Klutz. Ms. Klutz was returning from a restroom break when she experienced a fall to the floor as she attempted to sit down in her desk chair. The employer denied the claim, claiming Ms. Klutz fell because she was dizzy and passed out. The employer also argued Ms. Klutz was returning from a restroom break and was not performing any work activity at the time of the injury. Injuries sustained during a work break are work-related. This includes injuries while using or coming and going from a restroom. An employee does not always have to be performing a work-like activity for a workplace injury to be found compensable. Injuries sustained as a consequence of lightheadedness, dizziness, or passing out are not considered work-related. There are exceptions. If your work environment contributed to your symptoms, such as working in a hot or humid environment could lead to lightheadedness, dizziness, or passing out, such as from a heat stroke. This would be a work-related injury, and the employer would be responsible for any consequential injuries. Working in an environment around chemicals or fumes can also lead to lightheadedness, dizziness, and passing out, which would also be considered a work-related injury. If the passing out is from a non-work-related medical issue, such as a seizure, hypertension, or stroke, the employer would not be responsible for any consequential injuries. If you need more information about your workplace injury or Social Security claim, check out the rest of my videos on my channel or website. We make videos like this educating workers of all their rights when it comes to workplace injuries or Social Security claims. If you've been injured at work, schedule a meeting with us today and let us help you create a plan to get the compensation you're really entitled to. I'm Craig Armstrong, and I look forward to helping you.